one thing has happened in between before the declaration of unconstitutional. The bench declares it to be unconstitutional, does not make it prospective. And a petition is filed that now please declare it to be prospective. Can another bench do it? That would be the question.
No, I will slightly differ. See, even what is he talking about? He's saying for future lay down some guidance principle. Though I'm very doubtful we can as such lay down guiding principle. Only thing is we are flagging an issue, not even laying down a guiding. We are flagging an issue that while striking down a provision is unconstitutional, the bench is expected to look into the issue of the consequences. Beyond that, we can't say in this scenario you will do so. Again, it's quicksand to step into these issues. That we will not do. We are, I sometimes repeat, we are not theoreticians. We have to decide.
Lordships can consider it is desirable.
We have a list between us. Our job is strictly to decide the list between the parties, not to go beyond.
Yes, but not in a constitution bench format. That list may or may not be relevant. But your Lordships are deciding the question.
No, but we are not going to go here and there to decide.
No, correct. But that's.
Mehta, the difficulty was before the constitution bench. Yes, they had only deleted the words joint secretaries and above. It would have led to heaven because there would be large number of other cases where their junior officers would have been prosecuted. They would have then got protection of 6A, which could not have been.
It cannot be done.
It cannot be. So what they did was they struck down 6A, saying that it was discriminating. Now the very, very limited issue arises. Somebody is saying that in spite of the section being struck down, that protection will continue because I had committed the offence is alleged to have been committed during the when 6A was in the statute books. So declared by the court to be ultra-virus.
That is on prospectivity, not Article 20.
No, yes.
Yes.
So now, one is the plea taken on Article 20, which we'll have to deal with, saying that this protection is covered by Article 20, even if it's procedural. That we'll have to answer that one way or the other.
One way or the other. Not that it is covered. Lordships can say it is not covered.
Correct, you're right. And therefore, you have taken up the plea that it is procedural and therefore not covered. It's only the substantive.
And there is a substantial law.
You may be right on that. Let me put it, you may be right on that. There's substantive law and you just, I don't remember this. I don't know the judgment.
Well, that is Rao Shiv Bahadur.
Our understanding was also the same. We put that query to.
Yeah, my lords yesterday put that.
Now, the other issue is what is the effect thereof? The real issue is what is the effect thereof? When a statutory protection is withdrawn or struck down as unconstitutional, should we say that it should apply prospectively and not retrospectively? Because certain anomalies may flow in case we say it will apply prospectively. You are saying that we should not do it under, as a second bench, we should not be able to do it. But that may have its own consequences. Sometimes as judges, we may not be able to appreciate the full consequence. Look, legislation, when it is made, it studies data, examines various. We do not have that privy. Probably the bench may not be aware how many cases are there at the time when the judgment was pronounced, wherein 6A issues arising. So we may not be privy. So to say that the court cannot, in a subsequent bench, declare that it is prospective, may be a little difficult. In any case, suppose a review had been filed or curative had been filed, and we have cases wherein you have been filing curatives even with regard to the appointments, etc., of police officers, where we have modified the directions, keeping you the difficulties expressed.
Sir.
So that power, if you feel that power should be taken away from us,
no, nobody can take it away. Your lordships have conferred that power on your lordships, and only your lordships can take it away. I'm not on that. But the judgments have said so. That's my worry. It's not the case, my lord, as a proposition of it.
I will give an example. Suppose curative or review comes later on. That bench may not be available at all to decide who is to decide the review of curative. If we don't shut it out, you are in a review. If I may say so, on a constitution bench. which we have listed in the month of January, where you have come after, the government has come after 19 years in a curative petition without a review. Can we say this cannot be decided by any other bench than the bench which decided it?
No, but yes,
So far-
Union Carpet. Your lordships are right. No,
Therefore, we are circumspect in laying down very wide parameters for anything. Because there may be exigency of situation. Here the exigency is, and you are appreciating the exigency where, I don't know how many cases are left, but there is a hiatus period.
few and
You
far,
also feel-
mostly would be two, subsection two
You are
of
also
60.
wanting, as you have reframed 17A, a protection to be available against alleged to have been committed by a public servant under this act, where alleged offensive is relatable to recommendation made or decision taken. You yourself, the legislature in its wisdom, has given this protection.
Correct, Manoj. I am not against the protection.
So protection was earlier there, protection is now there. The protection, in some sense, you are saying is narrower because you have worded it in a more restricted way in some ways, but it is expansive in the sense that it doesn't restrict it to a particular category of persons, which was the cause for striking down as discriminatory. Therefore, that being the position, I thought everybody is on the same page, but we have to find a solution for the peculiarities of some cases which may be still pending, like
Few and far between us.
how to deal with them. That's the only thing.
Lord, that's the position, my Lord, in,
We are clear with what we want to do.
Lordship, only one last apprehension, my Lord, which I may share. Lordship knows, my Lord, Transmission Corporation refers to the larger bench saying that effect of Article 20 needs to be examined by a constitution bench. In 2010, Constitution bench said that now this becomes academic, and I'm sorry, and therefore we will not go into it because there is a new law in force. Again, my Lord, another bench, my Lord, referred it back to the larger bench. Lord, may I show only 3 or 4 judgments on Article 20, sub-article 2?
Yes, please do that, and with that we can close it.
Correct. That's all. And my Lord, another thing, and I'm not going to argue this. I join my learned friend, my Lord, in a request that there may be some guidance for future that while declaring a provision to be unconstitutional, it is desirable. May not be possible in all cases. It is desirable that the bench itself decides whether it should be prospective.
Shrestha, I'll only change the phrase. Instead of guidance, we'll flag this issue. So that
Yeah, whichever way.
if we flag the issue for further courts, that in certain scenarios it may be desirable to get into.
Yes, ma'am.
So that it's a little consciousness call.
Correct.
That we should look at the wider connotations of such an.
Understood. But another thing,
You have to leave something for innovations and lawyers also. You clarify everything.
My brother says we must leave something for the lawyers. Otherwise, if we clarify everything, what left to be argued by lawyers and further proceedings.
your lordships are right, my lord, everything should never be settled. My lord, another thing, and I'm not going to argue this, my lord, for your lordship's assistance. My lord, we have analyzed and, my lord, prepared the list of judgments where your lordships were pleased to say the grounds on which prospective overruling doctrine can be applied or may not be applied. That, if your lordships can consider, Lord, so that for future guidance, Lord, that ultimately your lordships would only flag. I have only one copy, other copy being, Lord, printed, but these are all judgments where, for example, my Lord, it says that prospective overruling not to be exercised generally in service matters. Then, my Lord, when it is to be exercised, what are the fetters?
Mr. Keep it in mind. Writer side, I'm conceptually against writing theses.
Lord, that's your lordships may say this in the judgment, my Lord. Everyone would be happy.
I've said so.
Everyone would be happy.
I've said so in judgments that we are here to decide on this. We are not theoreticians to decide a theory.
Because in many judgments, especially, my Lord, larger bench judgments, A concurring with B, B dissenting with C, but C concurring with A. We do not know, my Lord, what ultimately who concurred with whom.
That's the consequence. Apex court sitting in benches.
Correct.
Fortunately, unfortunately, that's the scenario. We generate so much of volume, we can't sit together and decide everything.
And, my Lord, your lordships would know better. In earlier judgment, 5 judge bench judgments, reference cases, 5, 6, 7 pages, and the law was crystal
But
clear.
then we were never burdened with 5 volumes of judgments, another 5 volumes from this side, 10 volumes. We have
Lord, there were no Xerox copies and there was cut paste.
There was no cut page, there was no computers. So nobody could at a click of a button, you have to do research, get all the judgments.
And
Now all these compilations are thrown at us and everything is reported. SCC also wants to make 20 volumes. Every reporter wants to make 20 volumes. Therefore, whether something is reportable, an order, a distinction between an order and judgment is also lost. Every order is reported. So we are actually inundated, I think, with case law. That is causing some constraint in writing and also creating volumes. Unless possibly we adopt the US system, partly we do, where they just refer to, below that line, they refer to judgments, refer to 15 will be itself. There is no discussion beyond that.
footnotes. That's
Only footnotes.
or my Lord, not a practical solution. There is a law that judgments would be written only in manual typewriters because the once 2 lines are amended by the honorable judge, the entire page will have to be retained. Lord, that makes it very crisp and brave. Otherwise, my Lord, the lordships are, this is on a lighter side. Obviously, it cannot be done. But otherwise, my Lord, it's impossible to cull out the ratio.
There is a I always say it applies to, I think, to drafting of petition.
Pleadings and judgments. Yes, yes.
There is a, in English grammar, I read a book, I think all of us at some generation read it, of Wren and Martin.
Wren and Martin, yes.
It's a red book. I always say in different forums of judicial academies, there's a very nice chapter on pressy writing.
Pressy writing.
Please read pressy writing. It's far more difficult to write 5 pages than to write 10 pages.
Lord Winston Churchill once wrote a letter of 10 pages to his friends, and he started that kindly pardon for a longer letter because I didn't have sufficient time to write a shorter letter. Because to write something very precise, concise, and short, you must be very, very clear about what you want to write.
That applies both sides.
Yes, yes, my lord. More on our side. My lord, we also,
Both sides.
my lord, we also, my lord, quote judgments, paragraphs of the judgments, and everything. My lord.
Actually, the one challenge has been the inundation of case law has created a challenge for us, which in 1950s the courts did not face. So you have 3-4 pages opinions which are there. They were not burdened with this volume of case law, nor were the legal fraternity burdened. So nobody, as you said, many technology changes have brought their own issues with it.
Yes.
There are not many reviews. People don't also really do that.
Whispering aloud what brother says, he said there were also not many reviews and curative petitions.
My lord, that is ingenuity on this side, my lord.
So sometimes we opened a curative petition issue. Today, I think in 1 month I must have signed at least 50 matters of curatives. Sometimes in trying to cure, you create a situation, but that cure creates its own problems.
Yes.
You wanted to point out those couple of judges.
Lord, a few judgments, my lord, only, and I will not be repetitive on Article 20, Sub-Article 1.
You've taken cognizance. I think that
Yes. Lord, please come to, my lord, my volume 2, because this is not in their volume, or they have not referred to some of them, and therefore, my lord, your lordships must not have marked. This, I'm sorry. Lord, I have checked up. In Transmission Corporation, only American judgments are cited, I have already pointed out. Even those judgment says what our courts have said. It doesn't say that procedural thing. I do not know, my lord, what prevailed upon us on this side not to assist the court with these binding judgments of constitution benches, which says that American judgments can be relied upon for Article 20 interpretation. Please see, my lord, 484.
One of the judgments, at least Mr. Datar referred to, I found that passage there that the American judgments have their own limitations in context of the American Constitution.
Correct. Well, every constitution evolves based upon our social ethos, our problem, financial position of the nation, etc. But there, a constitution can never be interpreted based upon judgment of other countries' constitution. But kindly come to page 484. At, my lord, page 488 first move.
Yes.
Lord, at 488, somewhere in the middle, Lord, since I am not taking your lordship's time, I am not reading the full. Lord, somewhere in the middle, if your lordships can come, which starts with on the footing, 10th line from the top, my lord. Lord, this is a constitution bench judgment. 5 judges in 53. So this Transmission Corporation had the advantage, but was not placed for your lordship's consideration. On this footing, your lordship gets him?
Yes.
Is it soon after Keshava Madhavan Menon?
Yes, my lord.
Three lines below that. 3 lines below that.
Yes.
From Madhavan Menon. 3 lines.
Keshwan Madhavan Menon, which documents are that?
Minister, instead of, if we take any of the SCRs, the SCCs,
The classitem.
photocopies, the advantage is that the concerned line and passage are there. SCC online doesn't have that facility.
Correct. And the classitum is also, classitum is not there. Please, similar, on this footing, it was argued that even on the assumption of the convictions in this case being in respect of new offences created by ordinance 48 of 49, after commission of the offences charged, the fundamental right guaranteed under Article 20 is not attracted thereto so as to invalidate such conviction. The contention, however, cannot be upheld. On a careful consideration of the respective articles, one is struck by the marked difference in language used in Indian and American constitutions. Section 9(3) and 10 of Article 1 of American Constitution merely says that no ex post facto law shall be passed and no state shall pass ex post facto law. But in Article 20 of the Indian Constitution, the language used is in much wider terms, and what is prohibited is the conviction of a person or his subjection to a penalty under the ex post facto law. The prohibition under the article is not confined to the passing or validity of the law, but extends to the conviction of the sentence and is based on its character as ex post facto law. The fullest effect must therefore be given to the actual words used in the article. Nor does such a construction of Article 20 result in giving retrospective operation. Lord, your Lordship, can skip and kindly come to para 9, the heart of the matter in my respectful submission. In this context, it is necessary to notice that what is prohibited under Article 20 is only conviction or sentence under an ex post facto law and not the trial thereof. Such the offence or the court different that which had competence at the time, I'm sorry, my lord, such trial under a procedure different from what obtained at the time of commission of the offence, or a court different from that which had complete competence at the time, cannot ipso facto be held to be unconstitutional. Procedure is not hit by Article 20, as my lord at the outset pointed out. A person accused of the commission of an offence has no fundamental right to trial by a particular court or by a particular procedure, except insofar as any constitutional objection by way of discrimination or violation of any other fundamental right may be involved. Now, your Lordship, my Lord, kindly come to what argument would be. This is a Constitution bench judgment, 5 judgment delivered in 53, not taken note of in my Lord Transmission Corporation, while saying whether it applies to procedure or not. First of all, it was not a procedural provision in Transmission Corporation. It was a penal provision of sentencing. So that question perhaps did not arise. Nonetheless, my Lord. Lord, now kindly, my Lord, come to the next judgment, 499, my Lords. That is State of West Bengal. Again, my Lord, a Constitution bench judgment, which was not placed, my Lord, for your for the consideration of the court. Here, my Lord, the court, para 13.
Could you repeat the page, please?
Lord, I'm sorry. It is page 499
490.
in my volume number 2. The citation I have given in the volume, so I'm not referring to the citation. Court comes out with a little nuanced argument on Article 20. That is para 13, 14 and 16. If your Lordships can, my Lord, oblige me by coming to page 505, running page 505. Lord, this was a case where in Calcutta, there was a divergence of view between two honorable judges in Calcutta High Court. I'm saying that because the names are mentioned, my Lord, that this view is right or that view is. That's only relevance, nothing else. Para 13.